Morning, everybody, and welcome to the District of Columbia Court of Appeals. We have two arguments on this morning's calendar. We will first hear argument in case number 24 AA 512, 1,000 feet versus DC Alcoholic Beverage and Cannabis Board. Counsel, whenever you're ready.
Your Honors, and may it please the court, Catherine McClellan on behalf of petitioners. This time I'd like to reserve 3 minutes for rebuttal, if that's okay.
Counsel, there might be a little switch on that podium to your left that will let you raise it or lower it.
Oh.
And it might help us if you could maybe just raise it a little bit, just so the microphone is picking you up. We'll give you a little extra time. Ricardo, I think, is nodding, telling me that that's as high as it goes. All right, counsel. Well, do your best.
Apologize, Your Honor. I'll try to speak loudly. Your Honors, today before you are petitioners who are parents concerned about a dispensary opening across the street from their children's school and their lack of ability to raise their concerns before the board. When these parents found out about Green Theory's application to license a medical marijuana dispensary across the street from Our Lady of Victory, they followed the board's procedures. They filed a protest letter. They opposed a motion to dismiss. They attended a roll call hearing. They filed an emergency stay, and they filed a motion to reconsider the order granting the motion to dismiss. But at every opportunity, the board denied them the opportunity to be heard. The board was incorrect in finding petitioners did not have standing and in granting the license. For this reason, the court should find for petitioners for 4 reasons. It was a violation of equal protection. It was arbitrary and capricious for the board to deny the petitioners the right to a hearing. There was standing, the petitioners did have standing because there was a contested case under the 3rd emergency rulemaking. And 4th, the license was preempted by federal law. First, it was a violation of equal protection for the board to make a higher standard for standing regulations regarding alcohol versus marijuana licenses. There is no rational basis for the board to consider the 2 substances differently. While they are individual substances, they are both regulated. They're regulated controlled substances, and the board has created a different standard. Under section 7.25601, under DC code section 25601, 5 or more individuals can come before the board to protest a liquor license. If the court accepts the government's interpretation, under DC code section 7-1671.06, only the A and C can protest a marijuana license.
So you're talking about statutory provisions here.
Yes.
So the argument is not that, I mean, the board needs to follow the statute. You're saying the DC Council passed statutes that violate the Equal Protection Clause because there is no rational basis for the distinction between who's permitted to challenge alcohol versus cannabis licensure?
That's correct, Your Honor. Under the DC regulations, 2 similarly situated individuals are treated differently, whereas under this court has determined in Dean that similarly situated individuals should be treated similarly.
I mean, rational basis is a pretty light thing. One rational basis you could come up with is that cannabis has medical benefits to DC consumers. And because you're always going to have some challenge to any new licensure, we'd rather be more permissive with the cannabis licensing and not permit any group of individuals to raise a challenge in a way that we're willing to entertain. We just want to get these things off the ground a little bit quicker. They provide more benefit to the community. I'm not sure if any of that's right, but it's an articulable thing. It doesn't strike me as irrational.
Respectfully, I disagree on 2 grounds, Your Honor. First, the board has conceded that it can seize the 2 substances similarly. In NRA-UND, the board said that it recognized there was harm with both substances when they were used by minors, and it used the analysis and whether to grant standing for a liquor license and considering another dispensary. On this basis, the board has stated that it sees the 2 substances similarly.
Who cares what the board says? Aren't we talking about a statutory provision? I thought we were talking about whether or not the council could give separate treatment to who can raise these challenges. The board can say whatever they want, but I thought the challenge is the council couldn't pass this law that gave disparate treatment. And if the board sees them similarly, I mean, similar, sure. Intoxicating substances that can be abused and they have various issues with them. But different in a way that seems important, which is one has medicinal use, and that strikes me as a reason enough to say the council isn't acting arbitrarily and capriciously.
Your Honor, that gets to my second point. While we've accepted that liquor licenses are a known commodity within the district, these dispensaries are a new idea. In this case, the board and the council should allow individuals the right to protest and kind of go through the nuance of how this is different, how this affects the community. Right now, the way the government interprets this statute, it's true branches of the government that are able to determine whether the board can grant this license. This doesn't allow for individuals to raise their concerns and is different than how the board views liquor licenses.
I mean, what's wrong with, I mean, you've been able, your clients have been able to raise their concerns, right? They've been able to submit letters and affidavits to the board, correct?
The board found in the order, denying the motion, in the order granting the motion to dismiss and the order denying the motion for stay and the motion for reconsideration, the board didn't consider any of these arguments. The board denied it purely on standing. So
Well, that your clients couldn't protest the licensure, right?
that was the board ruling.
But you could bring a superior court suit seeking an injunction if you wanted to, couldn't you?
Yes, Your Honor. However, the board itself has conceded under DC Code 2-510. It twice told petitioners that they could come before this court if there was any party that was adversely affected by an agency decision. The board now is saying that this provision is no longer applicable.
Yeah, they can come before this court. They just have to go to the superior court first. I mean, if the statement of the board is that even in a case that isn't contested, you can appeal this directly to the DC Court of Appeals. Well, that's just an incorrect statement of law, right?
Your Honor, there was a contested case before the DC board. Under the third emergency rulemaking notice, section 5432, there was an enabling statute which required a trial type hearing. In Burkhart, this court explained that there is a contested case when there is a trial type proceeding required by an enabling statute. The third emergency rulemaking required the board to determine the standing of potential protesters. And because of that, it was an enabling statute and it required several trial type requirements.
I don't follow. What about the hearing below resembled a trial? Were any witnesses called?
There were not, Your Honor. However, the parties were required to attend. There was no ex parte communications with the board. It was transcribed by a court reporter, and the board determined the standing rights of petitioners. Under Powell, this court has looked to factors within a hearing to determine whether it is adjudicatory or trial type. And those are.
I mean, all those factors sound like things that are true of congressional testimony as well. You know, you can subpoena somebody and force them to attend. Things can be transcribed. Decisions can be made at the end of those hearings. When you hear of a trial type hearing, you tend to think of evidence being taken. And would you say the evidence was taken here?
No, Your Honor, because the board didn't go past the standing discussion. It didn't reach the merits of the decision. It just accepted the application for the license for the dispensary.
In your view, was evidence required to be taken here?
Yes, Your Honor. Under 22 DCMR section 5421.3, sections A and B, the board was required to make a determination on the proximity of the dispensary to schools and the effect on the schools in the area. The board failed to make these considerations because the board didn't make a consideration beyond the standing analysis.
Is that something that would have required the board to do beyond some sort of official notice?
Yeah.
Like, is there a dispute about the physical distance between, or could there be a reasonable dispute about the physical distance between the proposed dispensary and the school?
Your Honor, the Green Theory and its application stated that it was more than 300 feet from a school. However, there was a daycare that was within 100 feet of the school. However, petitioners today, their children attend Our Lady of Victory, which was outside of the 300-foot distance, but within the 1,000-foot distance required under federal law. This was something that petitioners raised in their protest letter as an issue. They also raised issue,
But not as a factual dispute.
they raised that it was a fact, there was.
What's the factual dispute?
There was, apologies, Your Honor, there was not a factual dispute. The green theory stated that it was outside of the 300 feet limit that was the current DC code at the time. And petitioner's argument was that it was, however, it was within 1,000 feet, which is the
Right.
federal requirement.
Okay.
Petitioners needed the ability to have additional procedural safeguards in this hearing. They needed the ability to confront the witnesses. They needed the ability to determine the motive of green theory and opening in this location. These are all trial type procedures that they should have received before the board, and they did not. However, the issue is, while they should have received more process before the board, they didn't receive any process. That goes to my second point, Your Honor. And it was arbitrary and capricious for the board to deny them the hearing. Under Gerber, this court has stated that an inherently irrational decision is arbitrary and capricious. And this is a violation of the parents' substantive due process rights. They have the right to the ability under Troxel and under a plethora of Supreme Court cases. They have the right to choose the school their children will attend and how this school is structured. This right is not absolute. However, for the board to infringe on this right, they have to provide the parents with the opportunity to be heard.
Yeah, I don't, that seems like a very serious stretch to me. As are part of my rights as a parent to challenge licensing decisions of the people and companies that are near me. For example, do you think if my neighbor gets a medical marijuana card, I have a right to show up and before an agency, prior to licensing, challenge the decision of whether or not they should be able to get that card on the theory that my kids could see my neighbor smoking marijuana?
Your Honor, I would argue that that is more extreme. This is a dispensary that is opening across the street from the school where children are supposed to be nurtured, protected. And these parents determined that Our Lady of Victory was the appropriate school for their children to be educated. They did this under the assumption that they would not be exposed to marijuana, and that a dispensary would not open across the street. Because of that, I believe that is a different consideration because it goes to the parents.
It's different. I'm just trying to understand where your limits on sort of a parent's rights to, you know, freely choose school and parent their children. What limits, like, could your clients challenge driver's licensing decisions of anybody who lives in the area on the theory that they have a right to send their kids to a safe school? And dangerous drivers in the area could be a danger to their kids.
Your Honor, respectfully, I believe those are different decisions.
They're definitely different. I just want to know why you think this one is, it's more extreme. It is more in your face. I mean, I'm talking about a threat to their children's lives if they make a bad licensing decision.
Yes, Your Honor. However, here, the decision is not a licensing decision, which the district makes numerous times a day from numerous applicants. The decision relates to a controlled substance that is in violation of the federal law. This is a much higher standard in the court. This is something that the district is recently enacted. The parents should have the ability to make their thoughts known as the board determines how they should appropriately address dispensaries opening around schools. The board itself has agreed that there is an issue. In fact, after this case was before the board expanded the buffer from 300 feet to 400 feet for the distance between a dispensary and a school. This reflects the board's recognition that this is something that is a novel concept that is being decided and determined what the appropriate limits are, and that there is a harm when there are dispensaries across the street from schools. To Your Honor's concern that this opens the floodgates and allows parents to purchase anything tangentially related to their schools, I contest it's not. It's something that's limited. This court has created,
It's not a floodgates argument. I just want to understand the limits of your argument that parents, by virtue of their right to parent, have a right to challenge licensing decisions about the things that affect their children is way too broad. And saying well, limit it to this case is not the most satisfying principle. Sure, that would be good for your client. You could do that. It would just feel like a pretty ad hoc judicial rationale to say, but only here. We would need to explain why. You couldn't challenge licensing decisions of drivers and why you couldn't challenge the medical marijuana card for your neighbor at a licensing. All of those things seem quite extreme. And here, I mean, it strikes me as a fundamentally legislative question of how close and proximate you would permit marijuana dispensaries to open to a school. And we have a legislative determination about that. That legislative determination, by so far as DC is concerned, we have a different argument about the federal government, is 300 feet. Beyond that is fine. Now I don't know what, so I guess I don't know what right you're seeking to vindicate. It's a very ethereal one when you say, well, it's a constitutional right to parent your children. I mean, you could wedge anything into that.
Your Honor, I realize I'm out of time.
No, please.
Your Honor, I recognize the court's concerns. However, this is a fundamental right that the Supreme Court has time and time again upheld. It is found it is one of the oldest fundamental rights and is continually found for parents, even to the extent when parents went, and other courts have found, even to the extent when parents made the complete opposite decision of petitioners and they exposed their children to marijuana and other drugs. The courts found that the parents still had the ability to make these decisions as long as there was not harm to the children and the parents were not unfit to make these decisions. To the extent that your questions address the licensure of driver's license, I would agree that would be too tenuous. However, here there is a substantial harm because while someone may be a poor driver driving around the district, there's only, they potentially could drive by a school and could harm a child. I absolutely accept that that is a possibility. However, this is a much more realistic harm to these children. This dispensary is across the street from their school. They're exposed to marijuana on a daily basis and in a way that their parents have determined is not appropriate for their children. While these parents have the ability to make this decision and the board can infringe upon this right, there needs to be some process before the board, before the parents completely lose the ability to make this right and the board's infringement.
So let me get this straight. We're talking about who can challenge administrative actions by the executive branch. And I suppose that the starting proposition is what has the executive branch or the legislature said as to who can make those challenges? Sometimes they say certain people have a right to a hearing. Sometimes they say certain people can object, like in this case, they would say the only people who can object at the executive branch level are the ANCs and a few other people, not including you. Which is of course different from the question of standing to bring a lawsuit, which is an entirely different proposition. Now, if I understand you correctly, you're not claiming that any statute or regulation by the executive branch gives you the right to challenge it at the executive branch level. What you're saying is that the Constitution gives you that right. Is that, do I understand it? And so is the issue before us whether or not the Constitution gives you some kind of rights to in the executive branch action to be heard. Is that right? Do I have it straight? Or are you making additional claims of rights?
Almost, Your Honor. Petitioners have two avenues for standing. First is the constitutional standing that we've been discussing that Your Honor just brought up. Second, under section DC code section 7-1671.06A52, the language does not state that only the ANC is available, can contest dispensary licenses. As this court has explained in Exxon, if there is a limitation or a revocation of an individual's right, it must be expressed. There is no limiting language that expressly denies other parties the ability to protest a marijuana license. The board has the legislature and the board have found that when there is a liquor license, they've created that limiting language. One individual cannot come before the board, but 5 can as a group. The legislature has written in no such limiting language for a dispensary license. Therefore, the ANC is a party that can protest, but it has a non-exclusive list of parties that can protest under a clear reading of the statute.
Okay, thank you.
Additionally, your honors, this is the decision to grant Green Theory's license was preempted by federal law under the Drug-Free School Zone Act 21 USC Section 860 and the Controlled Substance Act 21 USC 841. There are restrictions on where drug transactions can occur under the drug-free school zone. They cannot be within 1,000 feet of a school. And additionally, the Controlled Substance Act states that that marijuana is a controlled substance that is illegal under federal law. While the government says that these two statutes, the DC code saying that there's a 300-foot buffer and the federal code saying that there is a 1,000-foot buffer can be complied with simultaneously, that's incorrect. These regulations create a physical impossibility.
No, I mean, it's not that they can be complied with simultaneously. Imagine that the district removes all restrictions on marijuana dispensaries. They say, we don't care. Open up what you want, where you want. It's just, a libertarian beacon for the world. You're gonna have to deal with the feds if you do it. Not our problem, though. Where's the conflict between those laws?
Your Honor, the federal 1,000-foot buffer creates a minimum standard. And other instances where the federal law creates a standard, other courts, including the Ninth Circuit, have reviewed state laws that cover the same regulated area. And when these state laws are not at the same level or above the minimum standard from the federal law, they've been preempted.
I don't get it. I mean, what's the conflict? What's stopping? How does it frustrate the federal government's interests if they want to enforce this statute? Why can't they enforce nothing about DC's licensure, which is simply DC saying, so far as we're concerned, you're fine. Nothing about that stops the federal government from enforcing its law.
The federal government can enforce its law, Your Honor. However, the board's decision to grant Green Theory's license was a violation of federal law and it was preempted. Therefore,
I still don't get it.
under
What does the federal law say? Does federal law say municipalities and states, you are charged with enforcing our federal law and you cannot grant permits or licenses that would be in violation of it?
No, Your Honor. However, under the DC APA, this court has jurisdiction and is required to invalidate agency decisions that violate federal law. Under that, this court has the ability to make this determination. Additionally, I would also argue that it is impossible to comply with both. Say in a hypothetical, similar to the Our Lady of Victory students, if there is a dispensary that is more than 300 feet but less than 1,000 feet, it is in compliance with DC law, but it is not in compliance with federal law.
But it's easy to comply with both. Just go more than 1,000 feet.
Yes, Your Honor, and that would be what hopefully the DC code to not be preempted would state. However, it doesn't state that. It states below the federal minimum.
Yeah, I don't get it. I mean, states don't need to have laws that enforce every federal regulation. So what's your answer? If there was a total absence of law here, and DC says we have no restrictions on marijuana dispensaries, we're not licensing you, but we don't care. We don't have any laws about it. You can do what you want. Subject to, being in a commercial zone or something like that, some basic zoning regulations. Do you think that's a preemption problem?
If DC had no regulation, if DC did not have a yes, Your Honor, I apologize. If the DC government approved of a license that is in violation of federal law.
I wasn't, my example was not approving a license, just no regulations at all. No license is needed. Go ahead and open your dispensaries wherever you'd like.
Then it would be a violation of federal law. There wouldn't be necessarily a DC code to preempt. However, it would still be in violation of federal law.
DC has violated federal law by not passing laws that enforce the federal law. That's like a commandeering problem.
The
Uh,
Green Theory's license is in violation of federal law because it is preempted by federal law, Your Honor.
So then do we need to analyze and look at that federal law and determine whether it should even be applicable? Do we need to go into the Commerce Clause and determine whether this affects something interstate and they even have a right to regulate a municipality, talking about licensing of entities solely in the municipality, dealing solely with the municipality?
Your Honor, I believe that isn't before the court today. However, the issue before the court is the board didn't consider the federal law when it was granting Green Theory's license. The board needed to factor this into its analysis, and its analysis is completely devoid of anything beyond the standing analysis. In that respect, it's on the board to make a determination, and then it could be, in theory, appealed to this court. However, that's not the issue today.
So you can have just a brief moment if you have a closing thought, and then we'll give you a few minutes on rebuttal.
Your Honor, I will wait for rebuttal if that's okay.
Very good. Thank you, counsel. Are you ready?
Good morning, Your Honors, and may it please the court. Thea Roshinariu on behalf of the District of Columbia Alcoholic Beverage and Cannabis Board. The court lacks jurisdiction to hear this case. As the court is well aware, its jurisdiction to review decisions of administrative agencies is limited to decisions that are made in contested cases, and that is cases where a trial type hearing is required by either a statute, a regulation, or the Constitution. And as this court made clear in Burkhart and Donnelly, it's not enough to say that an administrative agency has discretion to have a hearing. A case is a contested case only if the statute, regulation, or Constitution requires a trial type hearing. The Medical Cannabis Amendment Act of 2022 created a 90-day on-ramp period during which previously unlicensed establishments could apply to transition to licensed medical cannabis licenses. No statute or regulation required the board to conduct a trial type hearing prior to issuing such applications. The relevant statutory provision, which is DC Code Section 7, 1671.06A subsection H, expressly contemplated only one circumstance where a trial type hearing would be required, and that's where an ANC submitted a protest of the application. There's no dispute that no ANC submitted a protest. In fact, the ANC settled with the establishment. And the board's regulations similarly restrict the ability to protest and thus the ability to have a contested case hearing to an ANC. So the only possible basis for jurisdiction would be if the due process clause required some sort of trial type hearing, and it does not, for two reasons. First, there is no protected property or liberty interest here. Of course, parents have a right to guide the education of their children, but that does not create a property interest in preventing the government from licensing an establishment by a private party. And in any event, even if there was a protected interest here, in order for there to be a contested case, the court would have to determine that a trial type hearing is required with the full panoply of constitutional rights, including cross-examination and pretrial discovery. If any lesser or more informal process is required, then the case is not a contested case.
Do you think?
Could you state once again
Mhm.
the situation in which you think you're entitled to a due process hearing? You said property and what other kinds?
Property, liberty, or life, right? So if the state law creates a sort of property interest or liberty interest that is being abridged, then you would be entitled to some sort of due process hearing.
So I suppose the liberty interest in this case that they're arguing for is the rights of parents to protect their children or something like that.
It's at a very broad and high level of generality.
I grant you, but
We would say you have to identify an explicit and more narrow liberty interest. in
well,
order to-
the theory, as Judge Deal points out, would give everybody almost who's a parent a right to a trial type hearing for the vast range of administrative actions that are taken and legislative actions for that matter.
That's correct, Your Honor, and petitioners cite no authority that provides for a trial type hearing just because a parent or a right to raise their children, because education might somehow be impacted. So in order to have a trial type hearing, you have to have a recognized right by the state that there is a property or liberty interest. And there is no right to prevent a private party from opening a business. That has not been a recognized right, and petitioners do not cite to any cases or authorities that recognize such a right to prevent a private party from operating. And then even if you have a property or liberty interest, this court does not need to determine the extent of process that would be due. All it has to consider is whether a trial type hearing is required. If a trial type hearing is not required, then it's not a contested case. This court lacks jurisdiction, and petitioners would need to bring the case in the first instance in Superior
Well,
Court.
apart from our requirement about a contested case, can it be that the Constitution requires something less than a trial type hearing?
Yes, Your Honor, and this court has considered in various cases instances where some sort of hearing was required, but it was less than a trial type hearing. So for example, one of those cases is RO versus the district's youth rehabilitation services. And that was a case where a youth offender who was being recommitted to detention after a violation of a community placement agreement was entitled to a hearing about whether he had violated the agreement. But this court held that that hearing was not, that the due process did not require a trial type hearing. And the hearing itself in that case was not a trial type hearing because it didn't allow some of these procedures. And another one in Singleton, prison disciplinary cases. You are entitled to a hearing because that is a clear liberty interest. A lot of times prison disciplinary cases involve, someone being sent to solitary confinement or facing some other liberty restrictions. This court again said you're not constitutionally required to a trial type hearing with all of these procedures, and therefore some more informal and limited process before an agency is sufficient. And when that's the case, when the Constitution allows for a more informal hearing, it's not a contested case, and the precise limits of what processes might be due is something that would be determined by the Superior Court if the petitioners, bring that challenge there. I did want to briefly address on the merits a statement made in the petitioner's reply brief regarding the congressional appropriations rider that prohibits the Department of Justice from preventing the states from implementing their own medical cannabis rules. So petitioners argue in their reply brief that this prohibition does not apply to prosecutions under 21 USC section 860, and that's this 1,000-foot buffer zone. And in support of that, they cite a Senate report to an appropriations bill that was introduced in the previous Congress and that was not enacted. And so we see that Senate report has no relevance. The Consolidated Appropriations Act of 2024, which we cite at page 33 of our brief, is the relevant congressional enactment. It's what was in effect when the board issued its decision in this case, and it's the current law as well, because Congress has, enacted continuing resolutions to fund the federal government. And the current law makes no exception for prosecutions under 21 USC section 860. So I just wanted to address that. Unless the court has any further questions, we ask that the court dismiss this appeal.
All right, thank you, counsel.
Thank you.
And Ms. McQuillan, we will give you a few minutes for rebuttal.
Thank you, Your Honor. I just have a few points I'd like to raise from the government's argument. First, regarding the appropriations rider, while it is persuasive of the changing opinion to now enforce the Controlled Substance Act and the Drug-Free School Zone Act, this court should look to the text of the federal regulations themselves rather than whether they are being enforced or whether they're being funded to be enforced. Second, this court has raised the concerns, and the government repeated them, that this would allow petitioners or any parents to contest a wide variety of issues. However, this court already has substantial case law regarding disputes over liquor licenses. In these instances, the court has looked to whether the license and the establishment would affect the peace and order of the area, and they look to see how far away the petitioners are from the establishment itself. This court has clear case law from liquor licenses that it can apply to dispensary licenses and use that same analysis to determine when someone's rights are not actually being affected by a dispensary. Additionally, under the due process clause, under the due process analysis, it does require that to find that the petitioners have standing. Under the constitutional standing, there is a liberty interest, as Judge Stedman just brought up, in controlling the upbringing of one's children. For the court to determine what due process is available, it has to look to the Matthews v. Eldridge test and compare the private interest, which is the interest of controlling the education of one's children, and whether the erroneous deprivation of this interest or in the probative value of additional procedural safeguards, and then the administrative and fiscal burden, and balance these three factors together. Under the private interest, Green Theory has a license that it can renew indefinitely. While it's only in effect through 2026, there are no restrictions preventing it from continue to permanently deprive these parents the ability to control the education of their children. This is something the court has said that it takes seriously. Additionally, currently under the government's position, there is a legislative hearing. By definition, a legislative hearing applies to the public generally. It does not, by definition, it does not protect the individual interests of the parties because there isn't the ability to confront or cross-examine the parties and determine the motive. Additionally, while there would be a slight administrative or fiscal burden under DC Code Section 22 DCMR Section 5421, these procedures would only ensure that the board is complying with the regulations it is required to abide by, where it considers the proximity to schools and the effect on the schools in the area. To that extent, finish my sentence. To that extent, any additional burden on the board to comply with additional procedural safeguards would only ensure that the board is complying by the statute before it. Like I said at the beginning, Your Honors, this court should fine for petitioners because it's a violation of equal protection. It was arbitrary and capricious for the board to deny the right to the hearing. There was standing because there was a contested case under the third emergency rulemaking, and this is that Green Theory's license is preempted by federal law. If Your Honors have no further questions, I rest on my brief.
Thank you, counsel. The case will be submitted. Thanks to the parties for their briefs and arguments. We will now hear argument in this morning's second case, number 22 AA 871, DC Department of Corrections versus the DC Department of Employment Services.
Good morning. May it please the court. Lucy Pittman on behalf of the Department of Corrections and the Office of Risk Management. I would like to reserve 2 minutes for rebuttal. The CRB decision should be reversed for either one of two reasons. First, as a threshold matter, the CRB lacked jurisdiction to consider the termination of benefits under DC Code 1-623.16. But even if this court were to consider or to disagree on the jurisdictional question and consider the merits, the CRB's decision should be reversed because under point 16A, there is a prohibition on concurrent payment of the two types of wage replacement benefits that Ms. Brummel was receiving based upon her district employment. I'm going to start with the jurisdictional question. So as we know from many cases now, the Comprehensive Merit Personnel Act allows for workers' compensation decisions, 3 types of them, to be reviewed by the Office of Administrative Hearings. All other decisions are first reviewed by the Chief Risk Officer, and once you have a final agency decision in hand, can be reviewed in the Superior Court and then ultimately this court. The jurisdictional pathways has been abundantly clear since regulations were passed in 2016, and they were affirmed by this court in Frazier in 2020, and most recently in Butrago in 2024. The ORM decision here is stopping payment of benefits under point 16A, not one of the three types of decisions that can be reviewed by OAH, and instead should have gone the route that went to the Superior Court.
Can I ask you what in 0.16 gives ORM the authority to terminate or modify benefits?
Sure. So point 16A disallows what we would, I think, just say concurrent benefits, two types of wage replacement benefits. It would be workers' compensation benefits and retirement pay at the same time. And so the prohibition in 16, and this is getting more to the merits, I think, than the jurisdictional.
No, it
Okay.
really is a jurisdictional. I mean, my question is this: why isn't 0.24, 0.24 D1,
Sure.
sort of an initial constraint on when benefits can be clawed back at all? Why isn't the universe of cases in which benefits can be clawed back, reduced, or terminated, those outlined in 0.24 D1?
Sure. I would direct the courts to the Atkins case where the government was trying to read 0.24D broadly in that way, that when you can terminate benefits, it would have to be under 24D, and that was a termination case. And the panel there said, no, it doesn't fit one of the 5 conditions in 0.24D. And then said, but we leave open the door as to whether there's another provision of the CMPA that would allow for that termination of benefits. And so 0.24D, I read based upon the court's holding in Atkins as being a subset of terminations that have to then go through through OAH for review, but there may be another provision of the CMPA that could apply. And here, that other provision of the CMPA that applies is 0.16A, which doesn't allow for these two
What
types
was the name of the
payments.
case that you just mentioned?
Atkins?
Atkins. yeah.
Yes.
Okay, thank you.
But it sounds like you're saying Atkins left the question open of whether or not 0.24 D1. So I mean, what we said in Frazier and Buitrago, I think Buitrago we said sort of in a nutshell, what Frazier says is additional benefits do not qualify as modifications that you get a right to a full hearing before DOES. But we weren't dealing with clawbacks, with reductions or termination of benefits as we're dealing with in this case.
I mean, Frazier just factually was very different from here because there was no award to modify or to terminate. The award had been terminated for 5 years and the individual was coming back for a schedule award.
Right.
So it just never fit the 0.24D category, which is why Ms. Frazier actually never argued that it was a 0.24D case. And so Frazier really didn't go into great depth into what 0.24D really meant. I would say that the first time we really see that with any great extent is in Atkins, because there you do have the government saying, we're trying to terminate benefits. This seems like a 24D thing. And I get that, like, from that, it feels like a 24D thing when you're terminating benefits, but the court there said, no, unless it fits one of those 5 categories, it's not a way to terminate benefits. Perhaps you can find another place in the DC code to do it, but otherwise this isn't the route. Here we do have another route, and which we're stopping paying benefits. And it's a small thing, but I just want to make sure the record is clear. We're not saying that Ms. Brummel is not entitled to workers' compensation benefits or that her eligibility has changed in any way. We're simply saying she can't have both wage replacement benefits at the same time. So the amended notice of benefits in this case is relevant only to the extent that we're saying, if you stopped the retirement benefits, you can go back on workers' comp. You just can't have both at the same time.
But it's a
Yeah.
termination of her DC benefits.
It is, yes,
Sorry, Joe.
I just wanted to make sure that was clear.
But let me ask you this, to follow up on Judge Deal's question. The government had to have some authority, some source of power to do what it did here, which was to not permit her to have double compensation. An awful lot of these briefs focus on 24. And what isn't clear to me is why 24 applies at all. Because what is happening, it seems, is that the risk management people who are charged with the general oversight of this program are trying to enforce another provision of the statute, which is section 16. And if you look at 24 for your source of power, it doesn't seem to be there unless you look at D1. And what I hear being argued here is whether or not D1 provides an additional source of power to make changes beyond those that appear in D4. That is to say, does the change of conditions which authorize the mayor to make changes apply beyond the limitations that exist in D4, which talks about change of conditions to the claimant?
Sure.
But that's an interesting question, and maybe sometime you'll be invoking D1 or somebody else will be invoking D1. But it's sort of a mystery to me as to why anything in 24 has any relevance to this particular case in which was being enforced is not some vague change of conditions, economic conditions, this broad reading of the D1 power, which the CRB has, which is that, oh, well, any kind of change of conditions of government, recessions, inflation, whatever, even though it doesn't fall within D4 because it's broader. That's very interesting, but that isn't this case. This case is a section 16 case. And that's why I want to follow up on Judge Steele's question is, do you conceive of somehow or other section 16 gives the risk management people the power to, if not terminate, at least eliminate any cash payments under the workers' compensation?
Sure. So a couple of things. I agree with you that I don't think point 24 applies here. There could be a case in the future where D1 or maybe even D3 might come up as relevant. That hasn't really been the cases that we've had of late, and it's certainly not what's been invoked here. So we don't really need to go down that road. But here for 16, I would say, I would point you to the opening paragraph of A that does prohibit an employee from receiving compensation under this subsection as well as pay from the district. And we read, and we'll get into the merits discussion, that when we say pay from the district, that means pay from your district job to include the civil service retirement that you would receive from your district job. So we read the power that the ORM has to stop paying the benefits is that it needs to avoid a situation where they're in conflict with A, where both wage replacement benefits are being paid at the same time.
So tell me, you've referred to the retirement at least 2 or 3 times now as a wage replacement benefit. Why should we conceive of it that way? I mean, you can get a retirement from a number of ways. I mean, I know the section specifically excludes like military retirements, which, can happen when someone's extraordinarily young. I was at a military retirement last Friday for someone that's got at least 20 more years in their career. It seems to me the retirement is something you earn, not so much a wage replacement.
Sure. I mean, there's multiple ways of looking at a retirement annuity. One of the ways in which you can look at it is that you are no longer going to continue to work for that particular employer, and you're no longer going to be earning wages, and you'll be getting some sort of annuity as a replacement for that. It's a benefit that you get that money is set aside so that you continue to get for lack of a better word, income or pay of some sort after you're no longer working.
Yeah, and I
It's
get
not
that.
strictly a wage replacement, but it is generally thought of as one of the various ways in which when you're no longer earning wages, but that you still have pay coming
Yes,
in.
and I gain entitlement to that typically and under the old system and under the system that certain members of the DC courts, like the judges, are under for years of service, entitling me to certain amounts. At the point that the appellant, at the point, excuse me, that Ms. Brumell in this case was getting her retirement or was getting disability, was that paying into the old system? Or was that something she had already earned? And so we could fairly say the compensation that she's getting for her retirement is something that she earned before getting that disability entirely.
So for Ms. Brummel, she was a DC employee and she had two benefits that she obtained for being a DC employee. One was retirement and one was the ability to get workers' comp if you're injured. But you were not entitled to get both at the same time. And that's what we think point 16 reflects, is that you can have one of those benefits at a time, but not both.
I know that's what we're here to.
Right, and
clear
that
up.
is me jumping to the merits.
Yeah, and I want to get there, but if I take the view that these are very separate things and one's not a wage compensate, and one is not a wage compensation, the retirement's not a wage compensation. It wasn't necessarily entirely clear in the record to me, and I guess it may not have been that important of a point to the record when folks were looking at it. The retirement pay that she was getting was entirely, you would assume it's entirely based on the work she did before getting the disability benefits, right?
That would be my assumption, that it would be based upon her work when she was hired in 1972 until about 95. I might have it a little off as to when she stopped working. I think there was a period where she tried to return to work, but let's just say loosely for today, 72 to 95.
Okay, and if hypothetically there was a gap between those two things, is it just someone should make the economic decision to go with the higher, or?
Well, so in this context, there's nothing that prohibits her from turning off the retirement benefit. So I think what you're getting at is that at some point the workers' comp was turned off, I want to say in 2004, because there was an issue of whether or not she was cooperating with vocational rehab. And then it restarted again in 2006. We're not suggesting that her receiving retirement during that period of time was wrong. We're not even suggesting that anything bad on the part of Ms. Brummel. It's just that she can't have both. And so when she elected to have workers' comp in 2006, she should have turned off the federal retirement.
No, I understand that. I was more so feeling it out conceptually, and you
Sure.
answered it for me.
Sure, and we are jumping a little bit to merits. I guess I want to
Can-
make sure that
just
we
bef-
have jurisdiction.
Yeah, before we do,
Yeah.
I think I know the answer to this, but I want to make sure or see if you agree. If Ms. Brunel had already started receiving her federal retirement benefits when she first sought a disability claim and had been not denied disability benefits under 0.16,
Mhm.
she would have had a right to a DOES hearing, right?
So so if she had already been receiving retirement.
If this were an initial determination of no benefits because you have federal retirement coming in, if it were an initial determination or 0.16, she gets a hearing.
So I'm going to tell you why I'm struggling with this
Okay.
hypothetical, which is that she has to have been working and injured on the job and sought workers' compensation. So if
Let's
she's
assume
already
that that's not,
retired,
let's assume that's not a bar to receiving federal retirement benefits.
so
That
she's
they let
still-
you declare, we have a lot of US Marshals in this building that get pensions from MPD despite the fact that they're still working. That this is a retirement plan that you can collect while you continue to work. Just posit that.
Okay,
I don't know how true it is, but it's definitely conceptually not that difficult to think of. So she asks for disability and they say, no, you already are receiving federal retirement benefits. She gets a hearing on that, right?
I believe she would get a hearing under 24A because that would be an initial decision.
Right. So I mean, so the fact that you
so-
could deny it under 0.16 doesn't tell us anything about whether or not she has a right to a hearing. And the statute kind of says, well, for initial determinations, you get a hearing. For subsequent changes, you get a hearing if it's a modification, which I think we've interpreted to mean a reduction or termination in benefits, which would seem to apply here. but you think there's just sort of another universe of, and anything else? And
Sure.
any other, a reduction or benefit that you can't squeeze into 24D or, was it F? I forget.
24D and 24A is the initial and the modifications are the two. And then you get the actual
Mhm.
review under B and F for each respectively.
And then I'm just left wondering
Yeah.
why the heck 24D exists? Why is it specifying these situations where you can modify benefits when the answer is like, and for whatever other reason you can come up with?
Well, I don't think it is for any other reason, and maybe it will help. If I give you a couple-
Anything else that you can find in the law?
Well, it might help if I give you a couple of other examples
Sure.
of things that go to the Superior Court rather than to OAH. So for example, if you, there can be a suspension, forfeiture, or termination of awarded benefits based upon the failure to report earnings, and that's under 0.06B. That's an objective test, much like this. And so there you would get another decision, and it would go first to the chief risk officer and then the Superior Court. If you fail to pursue a subrogation claim under 0.31B, that would also go to the Superior Court ultimately. If you fail to accept a modified duty assignment under 0.47, paragraph I, or termination of benefits at 500 weeks under 0.06A, the permanency aspect of the 0.06 determination is done before OAH. But whether or not you're at 500 weeks or 400 weeks, if you're alleging, that goes to the chief risk officer and the Superior Court. And I will say this court in an unpublished decision in Lane, upheld that was the appropriate route to go, that this is just a determination of whether or not someone has hit 500 weeks or not. And that is a termination of benefits. And so I think the Atkins court was right when it left open the door that there may be other provisions in the code that can be used. It's not just trying to squeeze them into something else. But if it doesn't fit 24D, which here it doesn't, then you don't get a hearing under 24. You haven't identified anything else in 24 that would give you a hearing. And so we are in the sort of the same position of it's a 0.16 decision, and that goes to the chief risk officer, Superior Court, and then ultimately this court if needed.
Could you talk to me a little bit about how it conceptually doesn't fit under 24D4E, this idea that the mayor, the designee, determines upon strong compelling evidence that the initial decision was an error?
Sure, that's kind of going back to what I referenced earlier. The initial decision here is not an error. The initial decision was to award her temporary total disability benefits, and that remains good, valid, however we want to phrase it. And if Ms. Brummel were to turn off her retirement, she can go back to temporary total disability benefits. So there has been no decision that that initial decision was an error. It is just that she can't get both benefits at the same time. And that's what 0.16 gets to, whereas 0.24 is really talking about,
Well,
is the award appropriate for you or not?
In a
sorry, Judge
sense, there
Stedman.
was a second decision, you might say, I guess you could argue, that the government terminated her workers' compensation benefits on the basis that she was not cooperating. Then she challenged that. And then she got a ruling that was wrong. Now, your theory is, well, that all that did was to continue the original one. It wasn't a new
That's right.
award.
That's right. The 2006
Yeah, I
decision
see.
reinstated the initial decision.
But
And-
let me get back to this business here. If I get this straight, here's the way the statute's set up. As Judge Deal points out, originally you apply and anything goes. You get a hearing no matter what. You know, if you're denied or you don't get what you think you want for whatever reason, then you go down to D and you start talking about, well, what happens if somebody wants to change the original one? And D4 has limitations on when the mayor has any power to change it. And it says the mayor may only do it for these reasons, A, B, C, D, E. E may fit, but not very well. Okay, in this case, let's postulate none of them fit. So then you say, well, where does the government get the power to do what it wants to do? Now, you could look at one, which says the mayor has authority if there's a change of conditions, and the change of condition is she's now getting this money. But you don't want to do that,
Well,
because what you say is that the OAH has no jurisdiction to review that, because the only circumstances under which you can make a change are under D4. And if you want to make a change under any other reason, you better find it some other place in the statute. And then they say, you say, yes, there is another place, 16. Isn't that the dispute? And the appellant is that, not the appellant, the appellee is saying, no, they were acting under D1 because they terminated. In other words, any termination of the benefits is a D event. And the way the government has to justify it is under D1, and under D1, I get a hearing if they terminate me. I thought that was the major issue in this case.
so I appreciate the question, but I don't actually think that that is the major issue in the case. I don't see a D1 argument being advanced. And I do think the Atkins decision would have come out differently if D1 had been the ability, sort of just a very loose, broad, you can terminate benefits type of authority here. I think the way in which the case law has been coming out on this is that D1 sort of lays out that this is how you can modify an award. Here's some procedure that you can do. And then you look to 3 and 4 as to sort of when this can occur. 3 hasn't really come up because those are kind of summary terminations that just also just aren't relevant here. And D4 tends to be the source that people look to, because 1 doesn't really have a source specifically. It's kind of just laying out the initial, this is how benefits have to be modified. There needs to be, written notice and et cetera. And so
Yeah, but
it's possible that someone
the
could raise.
critical thing is D4 says you can only do it under 5 circumstances. Isn't that the whole key to this thing?
Yes, D4
Yeah.
says it's only under, and Ms.
And
Brummel,
if it doesn't fit under those, you can't change it.
that's right. Well, no, not that you can't change it. The Atkins court made that clear. You could still change it if it's under something else. It's just not going to be it's not going to be a D4 change. And so as I think the jurisdictional decision in this case can be written, it's that there isn't jurisdiction here because this wasn't a 0.24D modification as defined by Atkins. Atkins left open that there can be another source to terminate benefits. And if it's not one of the 3 that are identified in Frazier and Petrago, then you don't go to OAH and the CRB. You instead have to go to the Superior Court. And so this falls into, it's not a 24D. It's not one of the other 2 options for OAH hearings. And so this had to go to the Superior Court. If there's nothing else on jurisdiction, I will jump to merits. I do know that my time is up. But
We'll give you a few minutes.
on merits, I guess I just want to start with a little bit of history, because I think it's important to try to figure out what 0.16 means and why it means what we say it means. It requires a little history. So in 73, as Ms. Brummel points out, that's when you get home rule. The employees of the DC government between 1973 and 1979 remained on federal workers' comp, the FECA workers' comp. They also remained on federal civil service retirement, okay? Which means that a DC employee in 1976, for example, who was injured on the job would get workers' comp under the FECA, and if they decided to retire thereafter, they would have to elect either retirement pay or the workers' compensation benefits. They could not have both. So in 1979, the council adopted the CMPA, and it does two things that I think are really relevant here. One is it continued the civil service retirement, and that's at DC Code 1-626.02. And if you look at the current version, it has this exception for employees that were hired after 1987. That obviously didn't exist in 79. The period in 1979 was after the word all employees. So all employees, with the carve out for teachers and police and some others, were going to continue with their DC government job in order to receive civil service retirement. The other thing that they did at the same time was they adopted their own workers' compensation provisions. And that is what we're talking about now. And what they did, the council did, was they largely adopted the FECA into the public sector workers' compensation. They made some conforming changes, but they largely adopted it. And the purpose here is clearly that they were going to maintain that the employee who is only able to get workers' comp or retirement, but not both in 1976, wasn't suddenly going to change in 1979 and be able to obtain both benefits. Their goal was to simply adopt the benefit system that existed. So
Can I ask you a question? I don't want to interrupt because you're certainly saying, getting ready to make the argument. But if I'm a federal employee today, can I get both
no,
retirement and federal workers' compensation?
no.
So
And
why is a DC person supposed to get something more than they could under the pre-existing setup?
That's exactly where I was heading, Your Honor, which is that if we accept the CRB's reading of this, we have then what I would call three categories of employees. The federal employee, the pure federal employee, who can only get retirement or workers' comp, but can't get both at the same time. You would have the post-1987 DC employee, who I don't think there's any dispute in this litigation under this provision, could not get DC retirement and DC workers' comp at the same time. But then you would have this very bizarre group of third group who were hired prior to 87, who are entitled to civil service retirement, who would be allowed to obtain both benefits at the same time. And the reason I call it wage replacement is in part because I think most wage replacement we know is not a 100% wage replacement. Here, Ms. Brummel, if she receives both, would actually be receiving more than 100% of her wages, which would be a very curious thing, a very strange thing for the council to do when what its clear intent at the time was to simply adopt a system that already existed.
I agree with you conceptually. I think it makes sense. And I think we've seen scenarios where people going, I can think of at least one former judge, multiple probably of the DC courts that had a DC courts pension and went on to a federal court or came from a federal court and was able to double dip and get more than 100%. And I agree that double dipping is happening here. And conceptually, you've got me all along with you. I just wonder, city councils had a chance to clear this up. And in fact, they amended this in 2010, didn't they? And they added A1, which created some specific exclusions, but they didn't clear this up. So why should we not just go with what the plain reading would and seem to be to me and say from the District of Columbia?
So I think a couple of things. I think when the council added A1, it was doing so because there was confusion about disability retirement specifically. And there had been a case out of the CRB Carey that had decided that you could have both benefits at the same time. And so that clears this up. I will also say that A1 to some extent doesn't exactly match up with A. It does include federal employees in a way that I'm not entirely sure what that means. But I think from the council's perspective, they didn't need to clean this up. One of the things that I think is interesting and quite telling about the council's intention in 79 was that when they copied and pasted that, which is the FECA provision, paragraph 4 specifically had two references to the US code. It had a reference to the civil service retirement and it had a reference to schedule awards. Both were US code provisions. They changed the provision for the DC code to the schedule award to match the DC code, right? But it did not alter the reference to civil service retirement in the US code because they knew at the same time they were adopting 626, which is that you're going to continue your civil service retirement as a DC employee.
Sorry, please. Last point on this point. Apologies. Thank you, Judge Deal. if it was so clear, then why did ORM then try to clarify through regulations in 2017, the meaning of this?
I don't know if they necessarily were trying to clarify it or if it was just they were doing, they did a full sort of rewrite of regulations in 2016, 2017, and this was part of it. And certainly, I think this is another independent reason in which this court can reverse is that 7 DCMR section 134.2 makes it clear that when the reference to from District of Columbia, what that really is from your District of Columbia job. And so if you're getting retirement because of your DC job, then you can't also get workers' comp based upon your DC job.
I have questions about their authority to do that too, but I was interrupting one of Judge Deal's questions.
No, I mean, I was gonna say, it's usually a pretty bad sign for a statutory interpretation argument when we avoid the statute's text for so long. I get all the background. But squeezing this into being pay from the District of Columbia, because the District of Columbia paid into a federal benefit system, seems like quite a stretch to me. If the District of Columbia, gives a company a grant, and that company, and this guy is on the payroll, or this woman is on the payroll of that company and receives a paycheck, some number of those funds come from that grant. Funds are fungible. Would you say she's receiving money from the District of Columbia through that job with a private employer?
I mean, there are times where that is the case. I mean, I can think of examples of federal grants where when you're receiving federal grants, it's considered federal funds. And for example, the Hatch Act would apply differently depending upon whether you're a federal grant recipient or not.
It seems like an exceedingly broad reading of 16. And I mean,
But
it was a strange choice of words to say from the District of Columbia, if
Sure.
what you meant was from anywhere from whence District of Columbia funds might be traced.
Right, but I think that's where the history is so important because what could they possibly have meant in 1979 when they said from the District of Columbia and they referred to retirement? The only thing that they could have been thinking of was a civil service retirement because they also adopted that at the same time. And so in order to give meaning to these words and what they were possibly thinking, you have to consider that retirement pay in 4 has to mean civil service retirement. And in fact, we know it does because they explicitly say so. Otherwise, I mean, the only other option here is to give no meaning at all to paragraph 4 until 1987. And that would be even more curious to say that the council in 1979 adopted something, went ahead and made technical amendments to it by changing the reference to the schedule award to the DC code, but intended for it to have 0 meaning until some date in the future when they might adopt a new retirement system. And so that is why I think the history is important because it tells you what these words mean.
You sort of wonder where plain meaning goes when you have to stretch it that far.
I don't know that you do have to stretch it that far. And I think the regulation has sort of assists you on that in that you have 2 things. The district government does make contributions as it's required to do under the law for the retirement, for civil service retirement. So it's not as though this is like a fully funded federal activity. The district's funds are part of that. And that is required by law. And it is from their district employment. No one is suggesting that someone who worked for the Department of State for 25 years retires, gets civil service retirement from their federal job, starts to work for the DC government, gets injured, applies for workers' comp, would be rejected. In fact, that would be perfectly acceptable because that would be an individual who's not getting retirement from their DC job. So that would not be a problem. It's just that these are 2 benefits that are available based upon your DC employment. So I don't know if it's that much of a stretch to simply read from the District of Columbia as being from your DC job.
Well, maybe the Superior Court has to figure it out in the first instance.
I think that's right. I do think the jurisdictional question here is the way in which to resolve this matter. And I am way over time. And so if there,
Well, if I could
Yes.
kind of ask you one more question.
Sure.
On this, I kind of, as I hear it and I think about, and you're talking about these different categories, I just get to thinking, sí, ¿por qué no los dos? Why not both? That how big of a potential problem is that really? Is there this huge universe of DC employees that were working with DC prior to 1987 that this is impacting?
Not at this juncture, but that doesn't mean that this wasn't being applied appropriately for years. And that individuals were not getting double compensation for, and that this was just being resolved. It's unfortunate that this is coming up now at a time where I think probably a merits decision is not going to be applicable to too many people after this.
Fair enough. And so is it your sense, and perhaps that's more of a question for a court taking evidence, but is it your sense that there was a lot of double dipping going on at one point?
No, I don't think so. I think that this was, I know of at least one other case in which an individual had their benefits stopped because they were on the federal retirement based upon their district job. It didn't result in sort of anything. I think this is just being managed appropriately. And so I can't say that there's double dipping. I'm sort of hesitant to say something as double dipping because I don't want that might have a negative connotation. And I don't think anyone's trying to scam the government here.
Fair enough. Thank you for indulging me.
Okay, thank you, and I'll.
Thank you. We'll now hear from counsel for intervener. Ms. Brumell.
Good morning, Your Honors. My name is Harold Levy. I represent your intervener, Vera Brumell. This clearly is a termination of benefits proceeding. Ms. Brumell asked the court to affirm the October 17th, 2022 decision of an order of the Compensation Review Board, which in turn affirmed the May 13th, 2022 final compensation order of the Office of Administrative Hearings. The CRB and Office of Administrative Hearings orders reinstated Vera's benefits, which the Office of Risk Management terminated in 2020 based on its conclusion that the Comprehensive Merit Personnel Act prohibited Vera from contemporaneously receiving federal retirement benefits and workers' compensation benefits. As my colleague has indicated, Vera began working for the District of Columbia Department of Corrections as a corrections officer in 1972, several years before DC Home Rule and the adoption of the Comprehensive Merit Personnel Act. She worked her way up through the ranks at that time and for the next 21 years to the rank of captain, which at one time made her the highest ranking female officer, corrections officer at the DC jail. Vera was among a number of female officers, corrections officers at the jail, who in the 1990s were victims of a pervasive sexual abuse problem at the DC jail, which involved sexual harassment, sexual abuse, and sexual retaliation by male corrections officers, and not only corrections officers, but supervisors. Vera did not submit to any of the advances that were made by her supervisor, and she resisted the attempts to retaliate against her by her supervisor for failing to submit to those advances.
Counsel, I'm sorry to cut you off, but I think we're sufficiently familiar with the facts, and nobody is disputing your client's entitlement to continued disability pay, but for the double dipping into federal retirement funds, which that kind of gets us to the merits issue. But before we go there, can we focus on the jurisdictional issue a little? And I mean, their argument is, as I understand it, point 24D does not exhaust the universe of modifications and terminations, or reductions or terminations. They are citing me, and I will confess, I have to reread Atkins, but they're telling me that Atkins stands for that proposition, or at least left open that it doesn't exhaust that universe. Well, what's your reaction?
I believe that that's what the Superior Court, when they had the occasion to look at it, exactly what they said, that D1 is the greater universe of actions regarding modifications and terminations of benefits, and that D4 is a narrower confine within the D structure that provides that benefits may be terminated or modified based on a change of a claimant's medical condition, and those specific medical conditions for which termination can be granted and a hearing can be can be granted for which jurisdiction applies to have a hearing are those listed in D4. So yes, it's our position that D1 is a generalized statement of risk management's termination posture.
So
And
I've been.
and any change, including changes of economic conditions, which this clearly is. I think that the Superior Court cited a CRB case, Harrison, and discussed the matter fairly generally about economic conditions and the broader range of cases that involve conditions other than changes of a claimant's medical condition, for which termination can be granted and done, and hearing can be jurisdiction exists for a hearing under for OAH to hear those cases.
So I haven't focused, so I'm genuinely curious because I just didn't even look at this. Because of course your client tried to go through the Superior Court and challenge ORM's ruling. The Superior Court said, no, you have to exhaust remedies through OAH. Were the parties taking the same positions before the Superior Court as they are now? Was Ms. Brumell saying, we're here to be safe. This is a precautionary measure, but really we should be in front of OAH. And ORM was saying, no, we should be here. Well, were those their respective positions or has somebody flipped?
We did both at the time that this matter came up because we were completely unsure we did not agree that the Superior, we affirmatively disagreed that the Superior Court had jurisdiction. We were certain that OAH had the jurisdiction, but ORM took the position that that was not the case.
Right.
And so we went for both simultaneously.
Okay.
The first thing that happened was the Superior Court ultimately made a decision in the David Fant case, which ultimately came up before this Court of Appeals again, but dealt specifically with federal disability retirement benefits, not federal retirement benefits. And that Fant was the reason why in 2010, risk management asked the city council to adopt A1, which it did, which specifically only dealt with the combination of federal disability retirement benefits and workers' comp. At that time, Brumell was on the horizon. If the ORM wanted to have the Superior Court amend A1 to prohibit both disability retirement, federal disability retirement, and federal retirement, they certainly could have done that. But the fact remains, they didn't ask and the city council didn't grant it. So that left only A. And we would submit, Your Honor, that A doesn't cover this case, notwithstanding what council has alleged, because of the language of A specifically only deals with a claimant receiving DC workers' compensation benefits and federal and benefits from the salary pay or other remuneration paid by the United States. It does not mention salary pay or remuneration paid by the District of Columbia.
I thought they had
Well-
one. Sorry, please, John.
I was just going to say, D1 says the mayor may modify. Now, modification could go up or it can go down. But it's a very broad provision that says can modify.
Modify has always been construed to consider termination as well.
So is it your position that, if I just want to get this straight, that the mayor's action in this case was authorized under D1 because it was if it was authorized, it was a modification, and that D4 it doesn't matter because we're not talking about a change of conditions physically of the person, we're talking about other conditions, and that none of the D4, it's true that are you saying none of these D4, I'm not arguing that D4 applies. What I'm saying is, I meaning you, what I'm saying is it's a modification under D1 because it is modifying it by terminating it. And therefore you're entitled to a trial type hearing before the,
Absolutely, Your Honor. It
Okay,
is
that's-
it is a
that's-
D1
so it doesn't help
modification,
for the government, in your view, to say, well, we're not acting under BD1, we're acting under 16, which is a different provision.
Absolutely. It's a different
Yeah,
provision,
okay.
which
You're
doesn't,
saying terminate, modification is modification. I don't care what the reason is. That any modification, you get a hearing before the OA, before the CRB people.
any modification
That's got to be your position.
which amounts
doesn't it?
to a change, is based on a change of conditions, it gives grounds for termination and allows for an OAH evidentiary hearing. It's the two together. I mean, the first thing you get to is whether you have a D1 termination.
Well,
And if you
then you
get
can
there-
argue, I guess, whether this was a change of conditions.
Yes, it's a broader category than just a change of medical conditions. Otherwise, D1 is.
Change of
surplus.
conditions.
Let's
don't
take
know.
it beyond medical
I
conditions.
think you have to say it. Yeah.
Let's take it beyond medical conditions and say it, I understand the disability under the statute is typically under some of our case law, an economic thing. Is this modification referring broadly to just economics here, or is it physical?
It's certainly an economic. It's not physical because this case did not involve a change in medical conditions. This case exclusively involved an economic determination, which has historically been one of the underpinnings of the workers' comp program. It's an economic. Why would you allow change? Why would you base the workers' comp system on economics and then not allow a determination to be made based on economics? So yes, the Superior Court, Judge Higashi, when in her ruling, made it clear that this is an economic determination for which 24D applies. So
Am I reading the wrong order? Or maybe did you state the wrong judge's name? I thought this was Judge Pasachow. in this case.
Pasachow, I'm sorry.
Okay, there is a Judge Higashi, and I was
Judge-
wondering maybe there were two
Judge
orders.
Higashi was ruled infant
Okay, that's-
prior to.
I had
Judge
sort of
Higashi.
guessed.
Yes,
Um,
I apologize, Your Honor.
On the merits, they gave a pretty powerful response, I think, to the plain reading of 16A, which is, well, what is 16A4 doing there then? Because 16A4, passed before there were sort of district retirement plans. All this retirement pay was coming out of the federal government, and it says it makes an exemption for certain types of retirement pay that will not be precluded in A4 from, won't cut off disability benefits. And so why would that be there unless they meant the stuff that's coming from the feds? I'm not sure, it seems like a pretty good argument to me.
I think we have to look at what the city council did in 1979 and why they didn't do anything else after it. They clearly made a determination. We got to say that must have been within their determination to limit the contemporaneous benefits provision to the combination of DC workers' comp and any salary pay or remuneration, quote unquote, from the United States. Even after in 2010, if they had it within their desire to change, to also change and limit federal retirement benefits at the same time as they limited federal disability retirements in 2010, they had every right and opportunity to make that change. The fact that they did not speaks volumes for what their intent was and what ORM's intention was in not asking them to do it. They didn't ask them to make the determination. So from 1979, for 40 years, from 1979 to now, A has been limited to the combination of workers' compensation benefits contemporaneous with salary pay or remuneration, I have the words backwards, paid from the United States. And I think it's complete bootstrapping for risk management to claim that this is a DC, that the federal retirement benefits system paid by Office of Workers' Compensation within the Department of Labor is a DC sponsored program just because DC may have contributed to that program. DC contributes to, and employees contribute to Social Security as well, but that doesn't make the Social Security program a DC sponsored program. It's an independent, it's a federal program. I think it's wrong on the part of the Office of Risk Management to contend that DC, that federal salary pay or remuneration, that federal retirement benefits are DC sponsored just because they need to get that language, that bootstrap into 16A. Your Honor, we submit that 16A only deals with salary pay or remuneration at this point from the United States government, that this court had, that OAH had jurisdiction to hear this case, that this case was not subject to the rule that risk management adopted, by which they curtailed the Court of Appeals jurisdiction dealing with changes of condition, and granted hearing jurisdiction, for however limited, to risk management to itself. That was an arrogation of responsibility that was not countenanced by the city council at the time they adopted the CMPA statute, and risk management cannot adopt a regulation for which the city council does not first grant them statutory authority to do, which they did not. We would ask that the decision and order of the Compensation Review Board at this point be affirmed.
Thank you, counsel. Ms. Pittman, we'll give you a few minutes for rebuttal.
Before you start your rebuttal, let me ask you a question that I forgot to ask before.
Sure.
What exactly do you want us to do? I know that what you want us to do is to dismiss the case for lack of jurisdiction, but what happens next?
Sure.
She goes to the Superior Court and the Superior Court says, you know, I wrote a 17-page order which disposed of your case when you came down here and tried to appeal the decision. So why isn't that, I don't know, if it's res judicata or collateral estoppel or something like that, but you guys didn't appeal it.
Sure. So let me clarify a couple of things that happened at the Superior Court. So Ms. Brummel sought review at the Superior Court, and then she independently moved to dismiss on jurisdictional grounds. So there has not been a merits decision at the Superior Court in this matter. And she moved to dismiss, and the dismissal was granted. The DC agencies weren't aggrieved parties, so we wouldn't have been able to appeal that. But we did add in a footnote, I think it's footnote 6 of our brief, that we will consent to her reopening that Superior Court matter for a merits determination. Should this court agree with us that there isn't jurisdiction.
Okay.
But I thought there was, that is something I wanted to clarify, because it did seem like that was a little confused. I want to make sure that there isn't any confusion. Before the Superior Court, the parties that I represent took the position that they're taking here, which is the Superior Court was the correct place to be. And I just want to add a couple of things on the D1 discussion we were having. This is just not before this court as to whether it's a D1. Ms. Brummel makes one reference to D1 on page 23 of her brief, but and it's just a quick reference. It's really just a passing reference. The rest of her argument in this section, which is continues on 23, 24, 25, and 26, are all about D4.
Yeah, but I don't know how to read. I don't know how to read D4 without reading D1.
Well,
I mean, you can't read them in isolation. I mean, this is a starting point for every statutory analysis. Is you have to read the statute as a whole. And if you want to know what it means in D4 to say, when we're talking about a modification, well, D1 is very informative on that point.
Sure, but this would be a big departure from Atkins if we read D1 as being some sort of independent source for termination of benefits that doesn't fit under D3 or D4. Atkins was specifically about D4 specifically. I remember saying I remember saying during that argument that we haven't yet had a D3 case. We still don't in this case, at least. But we do need to have something to fit into one of those categories. And I think if we were to find that D1 is somehow an independent source, that would be contrary to
I don't mean it's an
Atkins.
independent source. I mean that you get, in order to modify, I mean, the position I'm floating is you don't get to modify, which means reduce or terminate benefits. You can supplement them without entitling somebody to a hearing.
It can also be increased.
Well, I think Fraser says probably, I mean, I think Fraser basically said
Yeah.
increases are out. But if you want to modify an award, well, what you need to do is you need to point to some change of condition.
Right.
That makes a lot of sense. It makes sense as a prerequisite to a modification of an award. If you don't have a change of condition, what are you doing with them? What are you doing modifying an award? That would seem like an initial determination for something new. So I don't really see D1. I mean, when I read the D4 argument and your position that D4 is sort of a subset of potential modifications, I mean, that forces me to look back at D1 and say, well, wait a minute. I mean, modification seems to be a prerequisite for any award change at all. I mean, this is not a subset of modifications. This is exhausting the field.
So here's what I would point Your Honor to.
Huh.
D1, the mayor may modify an award of compensation if the mayor or designee has reason to believe a change of condition has occurred. The modification must be in accordance with the following standards and procedures. So then you have a bunch of procedures. Then you get into, I will skip down to 3, that the mayor may not modify benefits unless, and that there's a list, and I always consider those to be sort of the summary ones because you don't have to do 30 days advance notice. And then you have D, here are the normal ones where you get the 30 days advance notice and hearing. Both 3 and 4 will get a hearing before OAH. But what I don't see in 1 is that list of like, what do we mean by modifying benefits? And we know from Fraser and from Atkins that it doesn't have to be just a 0.24D to be a modification. There are other provisions of the CMPA that allow for, and I'm going to say sort of colloquially, modification, because, and I kind of
But
gave you that
When you
list.
say colloquially, that's because
Well,
none of those provisions suggest you
modification-
can modify.
Because
that
modified, I
before.
think, is defined here. And I think we've kind of conceded nothing here, nothing in Brummel's case fits 4, right?
That's certainly not conceded.
Not conceded, but I think we've been discussing that we're having a hard time finding a way to find something in 4 to fit.
I mean, the CRB says it's a change of condition of economic conditions.
Sure, but the CRB, nor Ms. Brummel, identifies anything in the 1 through 5 of 0.24D4. And the court in Atkins, Fraser, and Petrago, I think, say that you need to be able to identify what in 0.24 you're pointing to as being the modification. And I'll go to the Petrago argument, right? In Petrago,
Why not 4A? Why not the disability has ceased or lessened when we consider disability being an economic handicap? The disability being the economic disadvantage to Ms. Brummel has lessened because now she's received federal retirement benefits.
I mean, that was the argument in Atkins that was rejected, that this was.
I've conceded I need to reread Atkins because I don't remember getting all this from it.
I'll tell you, the government tried to read broadly D4 to capture other terminations. And then you could have the OAH hearing, but that was squarely rejected by the court in Atkins. And so now we are in the position where we know we have to have it fit one of those 5. And if it doesn't, it's not a 0.24D termination. And that we have to then look to somewhere else. And I wanted to get back to the fact that 0.16 is an independent reason to modify these benefits.
Am I right? I mean, I'm just looking at Atkins and what I read it to say briefly, mind you, so I could be wrong, is that, well, this doesn't fit under 0.24, so you couldn't modify based on, I forget exactly what it was. Was it the remind me what
It was a termination of temporary benefits because the individual had reached maximum medical improvement.
okay, an MMI determination.
Yes.
Is not a basis that you can squeeze under 24. But we didn't say, but you can modify or terminate benefits for some other, under some provision. We said maybe.
The next sentence or two goes on to say, this doesn't mean that there couldn't be another provision
Right.
in which you could do that. And the problem you had in Atkins was if you didn't terminate temporary benefits, person couldn't receive permanent schedule award benefits because 0.07 says you have to cease temporary benefits in order to receive permanent benefits. And the court said, no, you have to have something for it to fall under 0.24D. It has to be one of these 5. It didn't fit into one of those 5. And so we weren't allowed to terminate under 0.24D. The language, though, is going to be interpreted the same as to whether or not it's a 0.24D for whether you get a hearing or not. And I guess I just want to make clear that while you don't get an OAH hearing for this particular modification that is taking place because it's under 0.16, you do get a substantial amount of process. This is an objective standard. Are you getting civil service retirement based upon your DC job? Are you getting workers' compensation based upon your DC job? If the answer is yes, then 0.16 applies. Why we would need to send someone to OAH for a full-blown evidentiary hearing with cross-examination and credibility determinations makes very little sense, which is why the CMPA did not put 0.16 into the list of things that get a hearing under 24B. Instead, it is one of those other decisions that this court in Frazier said was perfectly fine to go to the Superior Court route. In fact, as the discussion in Betrago was, that is the default. Capitol Hill Restoration in 1979 makes that clear, that if you don't have a mechanism for review, then the Superior Court is the way to go for agency review. And so that's what we have here is a 0.16 modification with review by the Superior Court. It's not a 0.24D argument. And I will just sort of, and I've already hinted at this, that Mr. Levy's remark that 7 DCMR 156 is somehow unlawful, that is completely foreclosed by Frazier. If there are any other questions, I know went rather quickly at the end, sorry.
Thank you, counsel.
Okay, thank you.
Thank the parties for your briefs and your arguments. The case will be submitted and the court is adjourned.